Okay, Nancy, I think we can go ahead and start.
All right, welcome everyone. We're so happy to have you here. We have another great turnout today, and we do ask that if you have any questions to enter them in the QA. We have so much content to cover in a short period of time, and we definitely will try our best to get to as many questions as possible. And I would like to take a moment to introduce ourselves. We have Brenda with us. She is our HR manager, and my name is Nancy, HR director, and we are part of the HR team at HR Partners. And please continue to keep an eye out for additional webinars to help you stay up to date on all of the changes that come our way. We have muted everyone and request that there not be any AI recordings during this presentation. And once again, we greatly appreciate you taking your time out of your day. And with that, I will turn it over to Brenda.
Thank you, Nancy. Okay, I am going to turn my camera off so we can focus on the presentation. Okay, so today we're going to be covering independent contractors versus employees, a little overview. We'll review the 1099 rule, a brief history of the new ruling, guidance on how we are to determine correct classification, consequences if we do misclassify an employer contractor, and action steps to reduce potential liability to your organization. So as of March 11th, 2024, laws are now being looked at the totality of circumstances instead of core factors like we've done in the past. This formally codifies the economic realities test. So the goal is to decide if the worker is economically dependent on the employer for work or is instead in the business for themselves. Um, Keep in mind that state laws can be more stringent. So, for example, California um, is a good example. It is critical to follow state-specific laws as well. So keep in mind where you are located versus an employee. Um, Misclassifications can be costly to the organization, so please look at these factors carefully. And remember that just because an employee is classified as a 1099, that does not make them a qualified independent contractor under the new rules. So this may significantly impact the construction industry, so resulting in more workers being considered employees, and it can also extend to temporary workers and subcontractors. So just something to keep in mind. So why is it that we are seeing this change now? So misclassification of workers has actually been on the top of the list for a while. The new 1099 rule is a reproduction of the Obama administration. Um, and federal laws are a part of the executive branch and based on current administration in the office. So, um, also, the DOL is charged with enforcing FLSA guidelines, but we're keeping in mind that there are 4 pending lawsuits based on this new rule alone, so we will probably see changes in the future. Okay, so 1099 versus employee classification. So the new DOL focuses on 6 different factors. The first one being the worker's opportunity for profit or loss. So this factor covers a worker's ability to negotiate their price of services and goods and making business decisions regarding marketing. Um, Next, we have relative amount of investment made by worker versus by employer. So here is the worker, the one putting in the work to buy tools, equipment, other expenses that they need to complete the job, or is the potential employee providing that for them? Next, we have permanency of the relationship. So this is how long, like the duration of the relationship. So we had a client um, that actually brought on temporary employees for a hurricane relief project. Now, the employees hired knew what work they were going to be doing. They already came with the skill set. So, for example, they knew how to drive a forklift, but still they needed to be told what to do, making them a W-2 employee. Next, we have the nature and degree of the potential employer's control. So this factor looks at the employer's ability to supervise the work, their ability to set their worker schedule, to limit the worker's freedom to work for others, things of that nature. So high degree of control there that we're seeing. And we have extent to which the work is performed, whether the worker uses specialized skills indicative of business-like initiative. So again, it is important to check the state level for additional tests. Okay, so when does a 1099 independent contractor apply? This is when it's not integral to the business. The worker has their own business. So questions we're asking are, does the worker maintain a marketable business with ability to negotiate prices of services or goods? Is there capital or entrepreneurial association? Does the worker have autonomy to make business decisions? Um, does the worker market to other businesses? So making sure that you're not the only business that this contractor is marketing to. And does this worker have business cards for their business? So an example of a 1099 would be, let's say we have a plumber's advertising their services online and through word of mouth. He or she is hired by homeowners or other businesses to fix plumbing issues. They're going to set their own schedule, bring their own material and equipments to get the job done. He or she are going to invoice their current clients for the services that they provide. Overall, they're going to enjoy that freedom of working as an independent contractor, but bear the responsibilities of managing business affairs, so such as finding clients, handling finances, ensuring compliance with tax and legal regulations. So again, that's a 1099 independent contractor. So when would a W-2 employee apply? So here we would look at, is the relationship indefinite? Um, this employee is going to be covered by employer's insurance. They don't provide their own tools or material. The liability cannot be transferred to the individual employee. The employee must be paid regardless of quality and timeliness of work. Employee doesn't make independent decisions for the business. The employee performs the work the employer exists to perform. And remember, independent contractors are not common in the organization here, okay? A good example of a W-2 employee is, let's say we have a marketing assistant with an annual salary of $45,000 a year. The employer will handle Social Security tax, withhold federal taxes, Medicare, state income tax, taxes from their check. Okay. And at the end of the year, this employee is going to receive a W-2 form from their employer, and it'll summarize total earnings and taxes withheld. This employee is going to be told how and when to do the job. Not much, they're not going to be deciding what work they want to perform or when they want to perform it. So here we have a nice infographic from the DOL. So on the left-hand side, you can see indicators of an employee, and on the right-hand side, we see indicators of an independent contractor. So for an employee, they'll be working for someone else's business, and a contractor is in the business for themselves. Employees generally can earn more by working more hours, where we see contractors increase profit through business decisions. Um, Typically, an employee is going to use an employer's material, tools, and equipment, and contractors are bringing their own materials, tools, equipment to complete the job. Then an employee is typically going to work for one employer, and sometimes this may be even prohibited. They may be even prohibited from working for others, where a contractor is working with multiple clients. The employee-employer relationship is continuing or indefinite. And for a contractor, those relationships are temporary. So we see those relationships last, they're project based. Um, for an employee, the employer is deciding how and when they will work, um, and the work will be performed, and contractors decide how and when they will perform the work. So they get to make that decision. Um, and employers assign the work to be performed to an employee. And again, a contractor is going to decide what work or projects they want to take on. So again, none of these are standing on their own or are more important than another, but good indicators to look at when classifying an employee versus an independent contractor. So important points to remember. No single factor is just positive. So all combined factors as a whole must be considered. Okay, so they're all indicators that we need to consider, and they're important. It's important that we do our due diligence to evaluate classification as well. More importantly, the DOL has more discretion to make a determination, but there is a lot of gray area. Um, Also, the DOL has more latitude. It will likely ramp up investigatory and enforcement activity. So, based on this new ruling, we do recommend you take this seriously. So, what happens if we do misclassify an employee or a contractor? The possible penalties include 2 years of back wages and overtime. 3 years can apply if determined that the decision was intentional. You can face tax liabilities, unemployment insurance owed, liquidated damages in an amount equaling up to 100% of unpaid wages. You can be responsible for their attorney fees and employees' attorney fees, fines ranging between 1,000 to 10,000 per violation, criminal prosecution, individual liability for managers or executives that were involved in that classification decision. Um, Personal criminal prosecution is possible. It's not common, but the risk is there. So again, please take this ruling very, very serious. Lead that way you're avoiding any cost penalties. The DOL can also share this with the IRS, and once the IRS becomes involved, additional investigation follows. So the IRS does an IRS test. So this test is to determine if a worker is an employee or an independent contractor. They're focusing on three different factors: behavioral, financial, and the type of relationship. So behavioral, you asked that question, does the employer have the right to control or direct how the worker does their job? Then you have financial. This is examining the extent of the employer's control over the financial aspects of the worker's job. And then, of course, type of relationship. So that's more of the duration. So, is there a shared contract? Is this project based? Um, so it is the job of the employer to disprove a determination was made. So again, being very careful when classifying. So now that we have all of this information, what should we do? We want you to understand all the tests that might apply, and that's federal and state level. Take a look at your existing 1099s, and you want to review the following questions. Do you have a signed contract in place? Is there a completion or end date? Has the 1099 contractor formally incorporated a business? How fundamental are the services performed? Does the worker bring their own equipment? What is the degree of supervision and oversight? Is the employee paid by the job or by the hour? Is the employer the sole source of income throughout the year? So take this time and remember, it's a good time to take a look at your workforce with a different set of eyes. And honestly, it might be a good opportunity to get organized um, when taking a look at existing 1099 employees. If a misclassification is determined, fix the issue quickly. Do not procrastinate, fix it as fast as you can. If you are someone that is on the fence of um, whether you want to classify someone as an employee or a 1099, we do recommend that you lean towards an employee because the cost of doing that isn't as much compared to the penalties that you'll face of a misclassification. Okay. Uh, and then if you have an employee that asks to be moved to a 1099, just tell them no, that that's not an option. To change an employee to a contractor would be considered a red flag, and we want to avoid that. Okay. Next, we'll review upcoming changes to new W-2 employee classifications. So a little overview. We'll talk about what is changing, the timeline of W-2 employee classifications, provide a little guidance on how to determine correct classification and action steps you can take to reduce potential liability in your organization. Now, you want to review current W-2 employees as well to make sure their FLSA status will stand through these upcoming changes. Okay, so two dates we want you to keep in mind are July 1st, 2024, which is around the corner, and January 1st, 2025. So we're seeing two different pay threshold increases, okay? The first one will occur July 1st, 2024, and the pay threshold is going to be considered non-exempt. So we'll see an increase to $844 per week or 43,888 annually. Then we have a second increase. So this additional increase will occur January 1st, 2025, and this additional increase will be at 1,128 per week, or that's 58,656 annually. So we'll be seeing increases, or it is planned to be increased every 3 years. But for now, these are the two that we're focusing on, July 1st, 2024, and January 1st, 2025. So we're going to have to look at these on an individual basis, right? Do they work a lot of overtime? Are they close to the new threshold in pay? Assuming that they do meet the requirements, are we going to change their pay or are we going to change their FLSA status? So for example, let's say that I have a manager right now who is currently exempt. And according to the rules in place, they make $50,000 a year. by January 1st of the next year, I need to decide if I'm going to raise their pay to 58,656 a year, or am I going to change them to a non-exempt employee? And if I do change them to a non-exempt employee, I'm going to have them clocking in and out. This non-exempt status would make them eligible for overtime pay. So if they work a lot of overtime now, then maybe raising the pay is the best answer. But if they don't, then maybe I just need to change them to non-exempt is best. So again, you're looking at these on an individual basis, determine if they're working a lot of overtime or not. And you can use that as a guide to make these decisions and what your business can handle.
Thank you, Brenda. You provided lots of very important and great information with a lot of specific details that we all need to use caution to remember. Next, we'll dive deeper into these new FLSA classification guidelines. As always, it's critical to review applicable state regulations based on your actual team. In summary, on a state level, 17 states have no general overtime pay requirements, pay provisions, and they must follow the federal overtime pay requirements, including the new salary thresholds, okay? And then we have 14 states and territories that either rely on or directly refer to overtime definitions, and they must follow the new salary thresholds as well. And then we have 20 states that have their own overtime rules in addition to the federal rules. And please be aware that laws typically favor the employee. And based on this general practice, if the state law requirements are less favorable to an employee than the FLSA requirements, they apply only to the employees not covered by the FLSA. And then when we have a situation where the state requirements are more favorable to an employee than the FLSA, they apply to all employees covered by the state law. So here you can see that the rules are in favor of the employee. Essentially, the law that has the greatest benefit to the employee will take precedence as a general rule of thumb. In addition, it is necessary to understand all applicable state regulations. We can't stress this enough that it is critical that everyone stays up to date on the updates and regulations. If doing your own research, please ensure that you're using credible sources. A general rule of thumb is that a government agency will provide reliable information, and just please be careful on the sources that you look at. All right. And now that we know the updated regulations, how do we make a sound determination of the FLSA classification so that we can be confident that our team is classified correctly and thereby reduce liability to the company? In a phrase, we say very carefully. Making a rash decision could create costly liability to the organization. Definitely something that we want to avoid and is avoidable if we are careful in our decision-making process. First, in addition to the new federal salary levels, an employer must review the actual work performed for each employee. Next, please remember that a job title does not determine whether an employee is classified as exempt or non-exempt. Rather, it's the actual work performed that must be considered in making a determination. It is really a common assumption that an FLSA classification can be applied based on title alone. However, in actuality, a comprehensive review of actual work performed is really needed so that we are confident in the decision. The FLSA requires that most employees in the United States be paid at least the federal minimum wage for all hours worked and overtime pay at not less than time and one half the regular rate of pay for all hours worked over 40 hours in a specified work week, unless they meet the pay threshold and pass specific exempt tests, which we'll review next. All right. And to determine whether a job is exempt and therefore not subject to overtime or non-exempt and required to be paid overtime at time and a half, a job or set of duties must meet the salary thresholds that we just reviewed. But in addition to that, they must also pass one of the following exemption tests to determine the exempt status. And the first one we have here is the executive exemption. To qualify for this exemption, the employee must be compensated on a salary basis at not less than the threshold amount that Brenda already told us about. The primary duties must be managing the enterprise or managing a customarily recognized department in the organization. The employee must customarily and regularly direct the work of at least 2 or more other full-time employees, or at least 51% of the time. And the employee must have the authority to hire and fire other employees, or the employee's suggestions and recommendations related to hiring decisions must carry weight. So their recommendation must be valued and be part of the decision-making process. Okay. Common examples of an executive exemption would be CEOs, mid-level managers, and also shift managers. And in all of these exemption tests that we'll review, the primary duty means the principal, main, or most important duty an employee performs. The primary duty must be based on all factors with the major emphasis on the character of the job as a whole. So in a lot of these decision-making processes, we have to look at not just one parameter, but a whole set. So we look at the overall picture. Okay, the next exemption we have is the administrative exemption. And this is a very common exemption that we see very often. The employee must be compensated on a salary basis at not less than the threshold amount, again. And the employee's primary duties must be the performance of office or non-manual work directly related to the management or general business operations of the employer or the employer's customers. And also the employer's primary duty must must exercise discretion and be independent with judgment in respect to matters of significance. So again, their voice must carry some weight. And the employee must have some level of autonomy in their regular day-to-day work. So they're not being directed on a close basis. Examples of an administrative exemption would be someone working in areas such as tax, finance, research, personnel management, human resources, and also purchasing. So any of these job categories would often involve an administrative exemption. Although, like I said before, we still need to look at the actual duties. We can't just use the title. And please remember that the job duties determine whether a position is exempt or non-exempt rather than the title. All right, we also have a professional exemption to consider. To qualify for the learned professional exemption, the employee, again, must be compensated on a salary basis, meeting the threshold. The primary duty must be the performance of work requiring advanced knowledge, and also in a field of science or learning. And typically the advanced knowledge must be acquired by a prolonged course of specialized intellectual instruction. Okay, and with this, the employee's primary duty must be the performance of work requiring advanced knowledge, defined as work that is predominantly intellectual in character and requiring consistent exercise of discretion and judgment. And these occupations typically have a recognized status and are distinguishable from other skilled trades. And examples of a professional or learned exemption would be areas such as law, theology, accounting, teaching, or also pharmacy. In addition to the learned professional exemption, we also have a creative exemption, which requires invention, imagination, originality, or talent. And examples of this would be music, writing, acting, and also graphic arts. All right, the next exemption we have is a little different. It has a different set of qualifiers. The employee must be compensated on a salary or hourly basis at not less than the threshold amount. So please note with this that this includes hourly compensation. And the employee must be employed as a computer systems analyst, computer programmer, software engineer, or other similarly skilled worker in the computer industry. The employee's primary duty must consist of the application of systems analysis techniques and procedures, the design, development, documentation, analysis, creation of computer systems or programs, the design, documentation, testing, creation of computer programs related to machine operating systems, or a combination of these duties requiring the same level of skills. Okay, the next exemption we have is the outside sales exemption. And again, this one is a little different. To qualify for this exemption, an employee's primary duty must be making sales as defined by the FLSA, or obtaining orders or contracts for services or for the use of facilities which will be paid by the client or the customer. The employee must also regularly engage in work away from the employer's place of business. And this is different than an inside sales position. So at this point, we're only referring to outside sales exemption. The outside sales exemption involves selling products and services in person. And this could really occur at industry events, trade shows, the sales prospects office, even a restaurant, or simply going door to door. And really the location depends on what reps are selling, industry norms, and the company's strategy. All right, the last exemption we want to review is highly compensated exemptions, otherwise known as HCEs. And on February 22nd of 23, the U.S. Supreme Court ruled that daily rate employees who earn more than $200,000 per year are actually not exempt from FLSA overtime requirements. The court's decision states that employees paid on a daily rate cannot be exempt with very limited exceptions, such as doctors and lawyers. And salary basis tests for highly compensated employees requires that employees meet both the duties test, which would apply to the executive, administrative, or professional exemption, and also be paid on a salary basis. The compensation threshold will increase to $132,964 annually effective July 1st of 2024. And then beginning on January 1st of 2025, the threshold will increase to $151,164 annually. All right. And there are some job duties that really don't follow FLSA exemptions. Not many, but there are some. The first is manual laborers, or what would be considered blue collar workers. These are individuals who perform work involving repetitive operations with their hands, physical skill, and energy. Examples of blue collar worker duties would be production, maintenance, construction, and similar occupations such as carpenters, electricians, mechanics, plumbers, and construction workers, okay? And then we also have what we consider first responders, including police officers, firefighters, and paramedics, okay? They're also not, they don't need to follow the FLSA exemptions. And examples of first responders are, of course, police officers, detectives, state troopers, highway patrol officers, paramedics, EMTs, ambulance personnel, rescue workers, and also hazardous materials workers. All right, so we have all this great information. What do we do with it now? We really encourage thinking through this very carefully, okay? The first step is to proactively review all job descriptions and ensure that they are up to date. We understand you guys are busy and you don't have time. This will take a lot of time to do, and it may even involve interviews with current staff in order to be sure that all the job descriptions are comprehensive and accurate. We understand this can be challenging, but it is such an important first step, so we know where to start from. If a position is questionable, it's best to classify an employee as a non-exempt status. The cost of doing so is so better than potential costly litigation, penalties, and repayment to employees, okay? Honestly, we can never predict what an employee may do. We may have a star model employee who has been with the company for 10 years. They're truly dedicated. You trust them explicitly, and then they decide to resign, or unfortunately, they may need to be terminated for cause. And so they may come back in the future and claim that they should have been classified as non-exempt and therefore missed out on overtime that was due to them. And as always, the burden of proof is on the employer. So if we can stay ahead of that curve, it's definitely preferable. As we mentioned previously, most employment laws support the best interests of the employee. That's a good thing, but that means that we as employers need to be extra careful. If an employee is classified by a company as exempt and not eligible for overtime, but the employee submits a claim and the courts determine that an employee really should have been non-exempt, costly fees could result, including unpaid wages, interest, damages, and attorney fees. And we never want that, right? In order to reduce liability, if you're unsure about what classification to use, we recommend consulting with a professional. If on the fence between a 1099 and a W-2, we recommend erring to a W-2 classification. If on the fence between an exempt and non-exempt classification, err to a non-exempt status. So if you think about it, all of these recommendations that we're giving you, they're based on the fact that they favor the employee, and therefore, if there were a claim, it would reduce liability to the company. Okay. Of course, it's important to review every position. If FLSA changes are necessary, document the change with each employee verbally, followed in writing. Ensure that each employee signs and returns the documentation. And then the employer should save the documentation in the employee's file for future reference. And as a best practice, we always recommend saving documentation in real time. So as soon as you have the signed document, go ahead and save it in the employee's file. So it's needed if it's available if needed by someone else. Waiting to save documentation until later should always be avoided. It may be necessary to incorporate a new timekeeping system to accurately track hours for non-exempt employees. It's critical that timekeeping best practices are understood and followed. One essential element is the understanding that an employer cannot make changes to an employee's time card without written documentation and approval from the employee. This documentation should also be saved in the employee's file and also in the payroll file. It is also important to communicate the timekeeping process to all managers and employees prior to the change and ensure that everyone understands. Non-exempt employees can only perform work while clocked in. Therefore, it's critical that they clock in and clock out at the beginning and end of actual work performed, not when they're scheduled, but when they're actually performing work. This will ensure that they are paid accurately for all hours, including any overtime that is due to them. And since this may be a new process to either the company as a whole, a department, or even an individual, it would be a great idea to track the timekeeping closely until you feel confident that the new process is being followed on a consistent basis. Ignorance of an issue doesn't alleviate the employer's responsibility in many instances. As we mentioned before, the burden of proof is always on the employer. So please do yourselves a favor and prepare for all of these changes in advance and before the changes are implemented, and then ensure that the changes are being consistently followed. We understand that this is not an easy change. Believe me, we understand. Some employees may view being exempt as more of a status symbol and may resist being changed to non-exempt. We see that all the time. Or they may not like the idea of having to clock in and clock out now. But leadership has a great impact on the way changes are presented and can really affect the view that the employee has. If you explain the reason for the change, allow them to voice their concerns, and then follow with an understanding but firm dialogue. And then chances are the employee will accept the change without reservation. And ideally, they'll see it as a positive. That's what would be the best case scenario. Excuse me. You could also explain that they are now eligible for overtime and they'll get paid for the actual hours that they work, okay? Which doesn't happen as an exempt employee. And in the end, consistency in all decision-making is critical, okay? This will help avoid a possible perception or claim of discrimination or bias. And if you would like to reach out to us for additional information, please don't hesitate to email us at myteam@gohrp.com. We actually had real quick, we had a difficult situation with a previous client where they required training during lunch, but the team wasn't getting paid for the training. And since the team was non-exempt, a claim was brought forward to the DOL by one of the employees, and the company unfortunately owed back wages and any overtime that was due. And this could have been avoided with awareness of the regulations and careful planning, okay? So it's so important that all managers are aware of FLSA rules before changes are implemented.
Okay, thank you so much, Nancy. That was a lot of good information there. Before we get to the questions, because we do have a few questions, I want to discuss a little of what HRP does. Um, we are a full service HR firm and we offer the following services. So a PEO solution. So this allows for saving in the benefits area typically and provides you a customized HR solutions. Um, we also have an ASO solution that allows for the above as well, but doesn't offer the same benefit options. And of course, there's HR consulting service solutions where we come in and assist with projects, audits, doesn't matter, you name it, and we're there. We also offer a great HRIS payroll and benefit system. So if you're someone that's currently frustrated with yours, go ahead and give us a call. We do offer webinars and training, so be sure to sign up. Now, if you're someone that joined this one today, you should get the invites. But if you scan this QR code, that'll take you to our um, website. And again, if you want to reach out to us, please email us at myteam@gohrp.com. We have applied for HRCI and SHRM credits, so if you'd like to email us, we can return that once approved. Okay, so now let's get to our questions. Okay. So Nancy, we have a question here. My organization does not implement time clocks. My recommendation is to have time clocks. What is your recommendation?
Definitely. Well, it depends. If you have non-exempt employees, 100%. So you can track the hours. If you have a full exempt team, which I don't think is very common, but if that is the case, then you could look at determining if that would be beneficial to you. But definitely, if you have non-exempt employees, it's so important to track the hours.
Okay. Okay, so again, if we don't get to your question today, please look to participate in future webinars, and you can also reach out to us directly if you have any additional questions. Okay, Nancy, so the next question we have here is, what if I have someone who has been a 1099, they want to remain one, and they have signed off on an agreement, but we're their only customer?
Yeah, the DOL and IRS don't look at the fact that you both wanted the 1099 arrangement, but instead whether the person qualifies under the new 1099 rule. Okay. And so you would receive any penalties if they didn't meet the qualification, not the 1099. It would be the employer. So please be very diligent in any decisions related to that.
Okay. Okay, so if someone is a supervisor now, truly meets all exempt checklists other than salary, do I have to bring them up to the threshold or pay them as non-exempt?
Could you repeat the question for me? Sorry.
Yes. So if someone is a supervisor now, truly meets all exempt checklists other than salary, do I have to bring them up to the thresholds or pay them as non-exempt?
Yep. We would recommend that you do an analysis on any positions impacted and see how much overtime they're working now. And like we said before, determine if it makes sense to move them up to the salary thresholds, increase their pay, or leave them where they are in compensation, but have them start tracking their time with the timekeeping system going forward.
Okay. Okay, next we have another question. If I have employees who are now going to be non-exempt because of this change, do I need to have them also enter their time now? So
Yeah.
they're going to be non-exempt.
Yeah, if they're non-exempt, we can't say that strongly enough. We have to be able to prove that we're tracking an employee's time. If an employee claims that they're due overtime that they didn't receive, the burden of proof is on the employer. And we're so busy with other things, it's better to go ahead and stay ahead of that and avoid this issue. So having them track their time is highly recommended. Also, please be careful to make sure the payroll team isn't making adjustments to the time cards. We mentioned that earlier in the training, but that's critical too.
Mhm. Okay, if someone pays for their own laptop, will that meet the IRS requirement of business investments by the employee?
No, because they're really looking at greater investments in equipment. And that examples of that would be a copier, larger equipment.
Okay, so bigger equipment. Got it. Okay, we have another question here, Nancy. What should we do if we have someone on the borderline of the salary threshold change that takes effect first? Should we move them all the way up to the January threshold or wait?
Mm-mm. I say it's better to wait.
Mhm.
We recommend looking at what you can afford as a company and what makes the best sense to the business. Definitely, we recommend bringing them up to meet the first threshold effective in July, and then wait to see if there is another change in January, because it may not happen. As we know, regulations change all the time. But at the end of the day, a company has to be able to afford the salaries they're paying. So that's an important factor in the decision making.
Okay, awesome. Okay, Nancy, and another question we have here is how many employees do you have to meet these guidelines?
Um, per the U.S. Department of Labor, employees who work for certain businesses or organizations, also considered enterprises, are covered by the FLSA. Okay. And so these enterprises, which must have at least 2 employees, are either those that have an annual dollar volume of sales or business done of at least $500,000.
Mm.
So that pretty much covers most people.
Mhm. Okay. I think we answered everything. We can give everyone a few more minutes if you want to add your question to the Q&A box. We are happy to answer more questions. Okay, Nancy, I don't see anything coming in. Those are great questions. Lots of questions. But again, we do hope that you join us all again for our upcoming webinars in the next couple of weeks. And go ahead and visit our website to learn more about us and our team. We've been supporting small to medium-sized businesses and their HR teams for the past 25 years now. We leverage technology with a team of experts that wrap around your team to be those extra hands. Um, we relieve your stress and try to provide a seamless and one-stop solution. We are a full service solution versus just a technology or self service solution. So go ahead and visit our site, reach out to us. Again, the email is myteam@gohrp.com. And Nancy and I and our team are here to answer any questions you have.
Yep.
We do look forward to seeing you all at the next webinar, and we hope you all have an amazing rest of your day.
Thank you, everyone.
Thank you.